The order following a review on a guardianship. Hi, I'm Darren Findling of the Probate Pro, and we're going to cover a particular form, scale form PC 637, scale for State Court Administrative Office, PC for Probate Court form 637. This order is used when a guardianship is being reviewed by the probate court. So don't confuse it with a guardianship order that appoints a person as the guardian, but rather this is when the court is reviewing the guardianship itself to determine whether any modifications are necessary, whether the person that is under guardianship is still alive, or whether the person is in need of the continuation of the guardianship. With all of the scale forms, they are created by various statutes and court rules. And in this particular case, you can see the statutes here that are referenced as well as the court rules. Now, again, you'll see there's quite a bit here. And we strongly urge you, if you're thinking about going through this guardianship process, or if you received an order like this, to work with a skilled, competent probate lawyer who understands how this process works and to be able to guide you through the legal proceedings. So let's work our way through the order itself and kind of understand how this particular form is used, and if you receive it, what you should do with it, and maybe interpret from the entry of an order. Now remember, an order is the court making a ruling. It's a ruling from the court that has to be followed because the court speaks through its orders. It directs activity and it directs the parties that are under the jurisdiction of the court relative to the order itself. Top left corner is the county upon which the guardianship resides, and the top right corner is the file number or case number. So in a guardianship file, it generally starts with the year and ends with a two-letter extension or suffix. That letter may be GA, for example, like an adult guardian, GM for a minor guardianship. Those are some examples. As you can see in the red box, I've highlighted the order, and it's following the review of guardianship. At the top, the in the matter of is simply the name of the person that's affected by this guardianship. So who is the guardianship over? And then the little check boxes on the right, is that person a minor or a legally incapacitated individual, which is an adult? So a minor guardianship, most people understand that a guardianship is different than custody. A guardian is generally a third party who is performing the role of a guardian over a minor. Or with an adult, it is that the person is legally incapacitated, adjudicated incapacitated, and now somebody or an agency has become their guardian. The date of the hearing and then the judge is reflected based on the entry of this order. And number two is really kind of the essence of this guardianship review. It says a review was ordered by the court, an investigation was made, and a report concerning the guardianship has been filed with the court. Now, in a normal rhythm or cadence in relation to guardianships, after 1 year, the guardianship is generally reviewed, and then thereafter on 3-year increments, minimally 3-year increments. And it really provides an opportunity to be assured that the guardian is performing their role, that the person that's under guardianship, as I mentioned earlier, is alive, and that the court can determine whether there are any changes that need to occur. So item number two is simply a reflection that there's been an order by the court to do a review of guardianship. And then here are the findings. The court finds, now subsection or paragraph 3, the little checkbox there says, no modification of the guardianship appears necessary from the information before the court. So in this particular case, somebody from the court, maybe a professional lawyer, a lawyer or other professional or guardian ad litem has gone out and done or performed a review and investigation relative to the guardianship. Now, if the court finds that a modification is necessary, a modification could be all sorts of things. It could be a limitation of the powers of the guardian. It could mean that there's a need to change the venue or the location of the court that is administering the guardianship because the person may have moved. It could mean that there is a need to terminate the guardianship or change from one guardian to another. Maybe the guardian has grown ill or has passed away, or can no longer perform the role. These are just some examples of where the court may make a finding in relation to a modification of a guardianship. Just an example. Subsection 4, paragraph 4, the little checkbox there, it says a hearing is necessary to investigate the issues raised by the review. So the review is done by the court-appointed individual or agency, and then if there's a hearing that's necessary, the court would make that finding. Now, the next section are the orders. These are the provisions in which the court is actually ordering things to occur. 5, the guardianship is continued without modification. The guardian shall continue to file annual reports, which is a requirement under statute and court rule for guardianship to do, at least annually, to do an annual report. Now, that box would be checked generally when the review says that things look good, that there's a need for a continuation of the guardianship. There's no need to change or modify in any way. The next is when the next review will happen. And as I mentioned, the normal cadence is then 3 years thereafter. Now, it may be less, but at minimally 3 years. Subsection 6, or paragraph 6, the little checkbox there, says that the guardianship is continued pending a hearing. So in the event that the court issues a hearing under the section a little bit above where the finding was that the hearing is necessary to further understand the information that was contained in the report, the court is indicating that the guardianship is still in effect pending the hearing that will be scheduled. And then there's a provision that identifies the name and address, and then it says is appointed attorney. So an attorney gets appointed for the individual under guardianship. Now understand that that attorney is not being appointed for the guardian, but rather for the person that's under guardianship to represent the legally incapacitated individual, and that they shall serve and file proper pleadings within 14 days of the appointment, and a hearing then gets scheduled. So that's part of the rules in relation to that review hearing that gets scheduled. Section 7, that little checkbox there can be checked. That provides that there shall be a hearing to be conducted to review the status, and this would relate to a minor guardianship. Very similarly as Section 6, but in a minor guardianship, there is a name of an individual, and rather than being appointed the attorney for the legally incapacitated individual, under subsection 7, the person is being appointed either the guardian ad litem or a lawyer guardian ad litem to represent the minor, to stand, to be able to speak on behalf of the minor at the hearing, to apprise the court of the nature of the circumstances surrounding the minor guardianship. Then there's a spot for the judge to sign and a date, and of course, the court can add additional information to the order, but this scale form has these presets that are in there to make it simpler to navigate and use as a court-related form. So again, if you get this form, you see this form at the bottom right corner, we urge you to read the statutes and court rules that are related to it. And of course, as I've emphasized earlier, and I emphasize in all the videos, you should be working with a skilled, competent probate practitioner who understands this particular area. At the Probate Pro, we are passionate about everything probate. If you have questions about a guardianship related issue or any probate or trust related issue at all, visit us at theprobatepro.com or call us at 1-833-PROBATE.